Thank you all for taking the time to come to this real important discussion on this very important issue that's facing the West. And thank you so much for taking the time to come and be able to ask questions, and hopefully we can leave here tonight knowing a little more about this issue and be able to make the well-informed decisions that I think we need to make down the road. So thank you again. Thank you for joining us this afternoon. We are pleased to present a forum for discussion regarding the transfer of public lands issue being discussed by western states with large amounts of federal public lands. Western Colorado is made up of approximately 70% federal public lands. Colorado should have this conversation and consider whether this idea has merit, and Club 20 is uniquely positioned to facilitate that conversation. This event has been planned to provide an opportunity for people to form an opinion on this issue. Many have already formed opinions regarding this topic, and we appreciate that. However, this is not a public hearing, and we are not taking public comments. We will provide an opportunity for questions from the audience later this afternoon. But comments will not be accepted in this forum. There are many venues to share comments on this topic, but this is not one of them, and we encourage you to seek out other opportunities to share your comments. We are pleased to welcome two knowledgeable speakers on this topic. Ken Ivory, a member of the Utah House of Representatives and President of the American Lands Council, and Doug Young, a Senior Associate with the Keystone Center and former Senior Policy Director for Governor John Hickenlooper. We would like to extend a special thank you to Doug for joining us. It's as Les mentioned, Professor Charles Wilkinson from the CU Law School was scheduled, but with the health issue wasn't able to make it. So at the last minute, Doug stepped up, and it's very important that we get all perspectives on this issue to be able to form our opinions. So we're real thankful that Doug stepped up, and we truly appreciate that. However, Professor Wilkinson has agreed to meet with us on January 7th, 4 p.m. at the Ute Water Conservancy offices. So we will still have him come and be able to talk on his perspective also. At this time, I want to kind of go over the format of how this will work. Each speaker will have 20 to 30 minutes to make a presentation regarding their perspective on the transfer of public lands issue. At the conclusion of the remarks, the moderator, that's me, will ask a series of questions that both speakers will be given the opportunity to answer. We ask that answers be succinct and to the point. The first person to answer the question will be given 30 seconds for a final comment after the second person gives his response to the question. At the end of the moderator questions, the audience will be given a chance to ask questions of the speaker. We want to emphasize that the audience may ask questions, and those questions need to be succinct and to the point also. Please do not attempt to make a speech or add lengthy background to your question. We will move on if a question is not readily apparent. We thank you for your cooperation. Providing the perspective in support of the transfer of public lands is Ken Ivory. Ken Ivory, Representative Ken Ivory of Utah, was elected to the Utah House of Representatives in November 2010. He and his wife, Becky, are the parents of 4 children. Given the daunting challenges that face the states and the nation, Ken took time from his business, mediation, and estate planning law practice to secure the blessings of liberty to his prosperity. Ken has developed and secured passage of legislation that is galvanizing a number of states and counties to exercise their atrophied jurisdictional muscles in response to their duty to restore balance in our system. These efforts include the Transfer of Public Lands Act and a package of bills backed by the Utah Association of CPAs to begin reducing state dependence on federal funds. And they call Financial Ready Utah. As the President of the American Lands Council, Ken dedicates his time to the educating the legislators and community leaders throughout the states about their jurisdictional rights and duties to manage, protect, and care for lands within the borders. Under Ken's leadership, the ALC is leading the charge to secure better access, better health, and better productivity of our public lands. Ken is the author of Where's the Line? How States Protect the Constitution. Thank you, Representative Ivory. Now, providing the perspective in opposition to the, will be 20 to 30 minutes, and you can give your opening comments.
Okay, is this on?
Yes.
Okay, great. Dave, thank you so much. I'm so honored to be here. Les and John and Garfield County and all of you for being here. What an honor. You know, this is a big time. And those of you that are in office, you're in office because of what a big time it is. You understand. I would much rather not be doing this. I have 4 children. I had a nice law practice. I actually made money and could take some time off and, spend some time at scout camp and working with kids and whatnot. But it's big. The things that we're facing are big. And you know that more and more with increasing federal control over our lands, access is being restricted. The health of our lands is being diminished and productivity is being depressed. So not continuing with the status quo and doing the same thing over and over again is simply not an option. And so it's time for a fact-based discussion on where do we go from here? Because, again, doing the same things is just simply not an option. I want to give you a little quiz to start out with, okay? So I want you to just think, see if you can guess which Western state has already succeeded in doing what we're talking about. They've already succeeded in securing the transfer of their federal lands. And they use these arguments. And so as you listen to these arguments that have already succeeded, I want you to think which Western state succeeded in doing this. So this comes right out of their resolution. So federal control over vast amounts of public lands within the state, like nearly 40% of Colorado and 70% of the Western Slope, restricts the state's ability to provide for and manage the growth and progress of the state, harms the state's ability to improve, protect, and manage its resources, and is detrimental to the state's ability to generate revenue. The statehood terms in the Enabling Act form an obligatory compact such that any act by the federal government to delay transfer of the public lands would undoubtedly be an infraction of the compact. Such an oppressive system of federal control over lands within a state has implications of the deepest magnitude and demands the most serious attention of Congress. Again, think of the Western state that you think this is, right? The issue of federally controlled lands involves questions of the highest importance to the state and the most intense interest of its citizens, such as, is it fair that the state is deprived of the essential powers and authority possessed by other states to the east? Should the state be deprived of the ability to protect the health, safety, and welfare of its people? Why shouldn't the state have the same authority to improve and regulate the growth and progress of the lands within its boundaries according to its own views of prosperity and happiness as possessed and exercised by states to the east? Is it fair that eastern states should subsidize the state because the federal retention of multiple-use lands deprives the state of the ability to generate revenue from vast areas of land within its limits? Why should the federal government exercise within the state purely municipal powers, like land use and planning regulations, that don't exist in other states to the east, which only the state and its subdivisions have the right to pass, which the federal government is not constitutionally authorized to exercise without the consent of the state legislature. Is a claim to such extraordinary powers by the federal government consistent with the rights reserved to the states by the Constitution, or are they expressly granted anywhere in the States Enabling Act? Finally, does the federal government have any valid and binding right to discriminate against the new states in the West by retaining forever federal multiple-use lands? Anybody have an idea which Western states successfully compelled the transfer of the public lands using those arguments? John thinks he knows. John, what's your guess? Hawaii's a good guess. In 1959, the federal government did transfer all the public land. Hawaii is one of the last states in, right, in 1959. In their Enabling Act, it says the United States hereby grants directly to the state of Hawaii title to all the public lands, title which is held by the United States immediately prior to its admission. Not Hawaii. Good guess, though. Yes, sir. Utah. No, Utah. Good guess. Yes, ma'am. I'll take two more guesses. Texas. No, Texas was a republic. Texas is the only state that's really different in this story. Alaska's another good guess. They were admitted about the same time as Hawaii. Hawaii got the best deal. Alaska got the worst deal. The western state we're talking about, folks, is Illinois. Illinois, 1.5 million acres had been disposed of since its statehood, out of 40 million acres in its state. For decades, the federal government controlled more than 95% of the land in the state of Illinois and Missouri and Louisiana and Arkansas and Indiana and Louisiana and Alabama and Mississippi and that great western state, because that's what they called themselves, that great western state of Florida. Right? This has already been done before. There are arguments where they're saying we can't educate our kids. We can't grow our economies. You're hoarding all of the resources. We can't improve the progress and growth of our community. You're exercising municipal authority within our states. And they banded together. And they compelled Congress to transfer their lands. You see, this is not, the newspapers are kind of funny. I mean, they're in the business of selling papers, and so they have to write stories that they think will get people excited to sell papers. You know, they're fixated on this deadline. There's no deadline in the legislation. We set a target date for the federal government to work with us on an orderly transfer for better access, better health, and better productivity. Do you know that Canada is doing this right now? Canada is working in good faith with its provinces and its territories. They've already transferred the land, resources, and water to the provinces, the Yukon provinces. Just this year, they've negotiated in good faith the transfer of land, water, and resources to the Northwest Territories. It's happening right now. What about the land of the free, the land of liberty and property and self-governance? You see, this is about getting to better access and better health and better productivity. Here's what Canada discovered, right? They discovered that where decisions are made by people closest to the matter, you get a better decision. So this is what we're talking about. I think I've got some slides we'll go through. And by the way, on the, let's see, how do I advance these? Where do I go to do that? I just click. There we go. Okay, now we got it. So on the American Lands Council website, you've got the resources tab, and then there's a library tab. You can go read that document, the Illinois Resolution. Now what I did was I updated that from 1840s language, really cool 1840s language. It sounds something like this. They say, should the oppressive system continue and no amelioration take place, it will not be denied that this question is susceptible of being presented in so grave an aspect as to involve considerations of the deepest magnitude and demand the most serious and enlightened reflection of those charged with the interests of the whole Confederacy. That was their resolution. You can read the whole thing on the website. You can read Florida's resolution. You can read Louisiana's resolution. Was interesting. They said, we request our representatives and we demand that our senators exert their utmost energies to secure the transfer of our lands. You can read those on the website. So, this is the question we've been asking for a couple of years. Why the difference? I mean, it's pretty apparent there's a difference, right? Pretty distinct, pretty stark. We've gotten a lot of interesting answers. We'll talk about them, but this is what we're talking about. We're not talking about the national parks, the national monuments. We're not talking about the congressionally designated wilderness. We're talking about the lands that are already designated for multiple use, and yet that use is being restricted, the productivity is being depressed. Liberty cannot exist. Hence, life has no real meaning without the right and control of property. It's essential to everything that we do, everything that we're about. This is not just a Western issue. And we'll talk about that a little bit more as we go. South Carolina did a resolution supporting the transfer of public lands. Many states to the east are doing resolutions. The Republican National Committee, not that this is a Republican or a Democrat or a left or a right issue, but millions of people not in the West have looked at this issue. They passed the resolution unanimously. The National Association of Counties not only passed a resolution supporting this, they've added it to the platform. Same with the American Farm Bureau and many, many others, local, state, national organizations. You can find many of those on the website as well. So this is the only solution big enough to get to better access, better health, better productivity. But the Supreme Court just last year, quoting cases where Alabama and Oklahoma and other states had issues in their Enabling Act, the Supreme Court, U.S. Supreme Court just last year said the constitutional equality of the states is essential to the harmonious operation of our republic. You see, one of the oldest political tactics in the book is divide and conquer. If you can separate out a different class of state, you have a back-of-the-bus class of states, you have a big red class of states, well, that's a political disparity that can be exploited. And our founders knew that centralized government grows, whether it's Republican or Democrat. I mean, that bears out. And you lose that local control of access, health, and productivity. Your forests tell that story. Your access to your roads tell that story. Your access to your resources, the millions of animals that are dying in the forest fires, more than 6 million a year, tell that story when you can't manage that local resource. So the very harmonious operation of the republic. It's also critical to balance federal budgets, eliminate national debt, economic self-reliance of state and local governments. You see, we need to help our federal government do well the things that it's supposed to be doing in this governing partnership, and quit trying to do better those things that it's not supposed to be doing at all, like land use and planning and local management, right? So this is about restoring the balance in that partnership because, you know, I can't keep this up to date fast enough. We just blew through 18 trillion. Does anyone know how long it takes to count to a trillion if you started right now?
You would not be alive.
You started right now, you think you'd be done by the time we're done here? It'd take you almost 32,000 years to count to 1 trillion. Or 18 trillion just in the direct debt. The unfunded obligations go way north from there. Now, Colorado, more than 40%, in fact, 46% of your revenue, single largest line item of revenue of the state of Colorado, as it is with all the western states, is federally sourced funds. And it's already going away. It's already going away. There are projects being cut back where the federal government granted money to the states to run programs. The state is the face of the program. The money's going away. The state is still there with the obligation. There are many, many examples of that. Of course, sequestration, cut Title I funding to schools, the PILT and the SRS that are on annual life support. We see this coming. It's just a math problem. That's what the American Institute of CPAs are saying. That's what Erskine Bowles, the Clinton White House Chief of Staff, who President Obama named as the director of his Fiscal Responsibility Commission, that's what they're saying. This is just a math problem. So, also national security. In fact, Lori Rewald is here. She was invited from American Lands Council to present at the Reagan Library at a national security conclave about a month ago. They're critically interested because you know that all of our technology, all these fun things, but more than just the fun things, our military technology cannot operate without rare earth minerals. Right now, 95% of them come from China, and they know it. And yet you have, all throughout the western slope, an abundance of rare earth minerals locked up in federally controlled lands, as we do in Utah. This is about national security as well. More than $150 trillion in minerals locked up in the federally controlled lands. More recoverable oil than the rest of the world combined, according to the Government Accountability Office testifying to Congress. More recoverable oil in Utah, Colorado, and Wyoming than the rest of the world combined, locked up in federally controlled lands. We have the realistic ability to achieve energy independence. critically, we're losing millions of animals. We're losing blue ribbon fisheries. We're taking forests that, I always like this example. This came from a commissioner in Idaho. Imagine if you had a pen that could hold about 50 cows. And you have water and food for about 50 cows, and you decide you're going to put 1,000 in there and walk away. You know what's going to happen. We have a forest that can sustain 40, 50, maybe 60 trees to an acre. And in most cases throughout the West, they're pushing 600, 700, 800, even 1,000 trees to an acre. They're getting sick, and they're dying all over the West. And we're seeing record-setting catastrophic wildfires that then wipe out the ground cover. You're seeing that more than anyone in Colorado. They wipe out the ground cover, and so then you get floods that wipe off the topsoil. In the fires, millions of animals are dying. Their habitat is destroyed. We're polluting the air instead of having a productive forest that we used to get paid to have someone garden for us. We would get paid to have people go out and thin the forest and sequester that carbon into homes and viable products that then created jobs, that then funded the economies. And instead, that's all going up in smoke. And with it, wildlife and habitat and fisheries and whatnot. Critical to public health and safety. Critical to protect our environment. Watersheds being gone. I had a county commissioner about 3 weeks ago said we're one spark away from losing our watershed. And we know it's coming. And yet we're prevented from going up to protect the health, safety, and welfare of our community. And we know we're one spark away. Protect our wildlife, critical. I mean, there are photos all over these sorts of things. Access. In Utah, we had 12,000 roads closed. We're having to file lawsuits to open 12,000 roads. We have 3.5 million acres that we manage. I mean, states already manage millions of acres of public land. People say, well, you can't manage your own land. We already manage millions of acres. States manage the land profitably. The BLM loses money in managing the public lands. The Forest Service used to be one of the top revenue generators. Unfortunately, the good people on the ground, their hands are tied. I sat next to a Forest Service worker from Arkansas flying to Oregon to put out fires. He says he's going every single week. We talked for 3 hours. I said, why are you going every week? There's no common sense anymore. We can't manage the forest where we have productive communities and a healthy forest. That's what we're talking about. We're talking about and, not or. Access. So out of the 3.5 million acres that we manage in Utah, for our school kids, our school trust lands, 1 million acres is locked up. Can't even get to it. The roads have been shut off. It's landlocked by federal land around it. We can't even get to 1 million acres that we already own. We're losing access all over the West. For our economies, of course, you understand that better than anyone. You know the opportunities with the economic study. Some of you have heard just last week, week before last, we funded a $500,000 study that we spent a year and a half. We had our 3 top universities, economics departments of our 3 top universities. They produced an 800-page study. It's online. You can go get it. But this is just part of their summary. The study contains extensive useful information, should be read as an integrated whole to appreciate the complex interconnected nature of the economic and cultural attributes of the public land. Most significantly, it demonstrates that a transfer of the public lands can be an economically sound pathway to a more balanced public lands policy. The study demonstrates that this can be accomplished without sacrificing the beauty of our state, the quality of our life, or the attraction of Utah to tourists and recreationists from around the country and the world. This is what we're talking about. We're talking about federal public lands become state public lands for multiple use with local planning. What you'll hear very often, and I'm sure Doug won't go there, but what you'll hear from some is the sky is falling. You can't manage your own land. If you managed your own land, everything would fall apart. Well, no, we've done it for decades, for centuries, but that comes out over and over and over, and you can't afford to manage your own land, those sorts of things. So it's a matter of that local control. So this tells the story so graphically. And you have the federally controlled lands, and then to the lower left, wildfires more than 250 acres. And then the top right, the wilderness and roadless rules. And then to the bottom right, $150 trillion in mineral value locked up in the federally controlled lands. I mean, if a picture tells 1,000 words, this tells hundreds of trillions. That is locked up. We're locking up our productivity, locking up the health, locking up the access to the lands. So some of the basics, this was a slide left over from, I did a presentation in New Hampshire. They invited me to come to New Hampshire and Texas. I just came back from Washington, D.C. I got back last night. About 10 o'clock, I slept for I had the first night in my own brand new bed with my wife, and I had one night in the bed, and then we were up to come here to be with you nice folks, so I didn't get a chance to change some of those slides. But we need to find the people that have the knowledge and the courage to battle for, not against anyone or anything, but to battle for a solution that's big enough for better access, health, and productivity. Go through some of these things. This is one of our favorite Supreme Court justices. He's our only Supreme Court justice from the state of Utah, United States Supreme Court. Man has 3 great rights: life, liberty, and property. They're so connected as to be a single right. Because if you give a man his life, but take away his liberty, you take away all that makes life worth living. If you give him his liberty, but take away the property, which is the fruit and the badge of his liberty, you still leave him a slave. We have a job to do as we recognize the veterans battling for the principles that have made this nation great, the laws of liberty, the principles of prosperity, the pillars of peace. We have a decision to make on what we're going to pass to our children. A very real decision, in my opinion, which is why we're engaged in this. I wish somebody else would pick up the torch and run with it. It's so tremendous, but what an opportunity. So this is one of the things that comes up is, well, you gave up the land at statehood. You just gave up the land. Think about that for a second. Just think about it logically first. Think about these pioneers, these rugged folks that came west. Why did they come west? They came west for property, for liberty, and to govern themselves, right? And so the story is that their very first act of statehood was to give up their land. Does it make any sense at all? Well, it doesn't make sense because it makes no sense. But what they say is they'll point to 6 words in the enabling acts of the western states and say, the people of the state forever disclaim all right and title to the unappropriated lands. And they say, you see, because the western states, we've looked at all the enabling acts of the western states, and they all say that, therefore you gave up your land. But you see, that's Alabama's enabling act. They were one of those states that was 90% federally controlled for decades and banded together and battled and secured the transfer of their lands and succeeded along with Illinois. You see, forever disclaim all right and title. You see, that's Louisiana's enabling act. Some people say, well, somehow in the Louisiana Purchase you gave up the claims to your land. Louisiana has the exact same language. Colorado is very unique. Colorado and Wyoming actually have land that are part of the Louisiana Purchase. You have the same claim that Louisiana has. Forever disclaim all right and title. You see, that's Nebraska, right to your east. 1% federally controlled land. Exact same terms in their enabling act as Colorado. Forever disclaim all right and title the unappropriated public lands. You see what that is? Any real estate folks in here? Anybody in real estate? You guys are all in real estate. So counties, you're all in real estate. Do you know what an escrow is in real estate? In the middle of the Revolution, there were 7 states that had claim to the western lands, 6 didn't. They're out of money. They can't fund the war. And they're almost at the point of a meltdown, a civil war, if you will, in the middle of the Revolution. How are we going to fund this? Statesmen that they were, they said, we'll take our claims to the western lands, we'll put them in an escrow. And we'll form this new confederation of our states, our confederation, our office manager, if you will, and they'll be the escrow agent in this escrow that we set up to hold those lands, to pay the debt of the war, and to create new states with the same rights of sovereignty, freedom, and independence as all the other states. Those documents are all online as well. This language was the quit claim that put that title in escrow to be held in trust for the states ultimately to be created. You know, there's Supreme Court cases that say that exact thing. The Congress only holds title, the federal government only holds title in trust for temporary purposes for the states ultimately to be created. He said that over and over and over again. I'll show you some more things here, but I hit the wrong button. That's your enabling. How we got? About 5 minutes. So in your enabling act, you were granted some school trust lands, as were all of them, as was Ohio, as was Illinois. Some people say, well, that's different. You were granted school trust lands. That's all you get. Well, so was Illinois. So was Louisiana. So was Nebraska and whatnot. This, in 1932, the states had begun banding together to do just what Illinois and Missouri and the others did. By 1932, there were congressional hearings. The title of the congressional hearings, granting remaining unreserved public lands to the states. They're at the point of a bill to do this. Now the agencies stepped in and they said, okay, we're going to grant you all the land. We know it's a solemn promise. It goes back to the Revolution. It's in the Enabling Act, Supreme Court statements. We're going to grant you all the land. We're just going to keep all the minerals. And the western states banded together. In fact, our governor, Democrat Governor George Durham from Utah at the time, said, no, if you take everything that's worth any value and leave us with nothing but the skin of a squeezed lemon, we can't tolerate that. You have to keep the whole promise. And the western states said, no, you can't do that. I've heard Mr. Salazar and I've heard others say, well, the states were offered the land at one point. They didn't want them so they could never have them again. Well, the states were offered the skin of a squeezed lemon. They were never offered to keep the full promise. This was that's online, but that's your own statements in that 1932 case where they said, I don't know if I can back up. I don't have to back up on this. I don't think I can do that. Oh, there we go. So you see, this is Colorado. This is your state board of land commissioners. The state is entitled to and should receive not only the surface rights, but the subsurface as well. The state can administer these lands better than someone far away. When authority is located afar off, down in number 6, it necessarily is less well-informed, less sympathetic, less responsive to public requirements. When it's close at hand, it's more likely to be executed in the public interest. Because if it's not, you can vote them out in the next election. You can go right to their house. Now look up at number 1. Of all the we contend that in equity and justice, all the unappropriated lands belong to the state, and that the federal government is simply holding title as a trustee. They do hold title as a trustee. Let me just show you this and we'll kind of conclude on that. But going back was the map. Can you back up to that last slide if you don't mind? This is when the western states were more than 90% federally controlled for decades. You see Illinois there, right? Do you know how it happened? How it got started? It was one man. One leader stepped up and said, my election to the United States Senate found me doing battle for, not against anyone or anything, battling for a solution to change this system of disposing of the public land. He said, I resolved to move against that whole system. I did it in bills. I also went out and educated the public, because that's where the power lies. And he says, members of Congress and the leaders and county commissioners and state representatives and governors and attorneys general should not intermit their exertions or vary their policy, but fix their eyes steadily on the period of the speedy extinction of the federal title to all the lands within their boundaries. And they did. You see, this is not just a legal effort. It's not just a legislative effort. It's not just an education effort. It's all of them. It's already been done before. And as John pointed out, Hawaii mobilized that same way at their statehood because they were disaffected. Some of their lands had been taken away when they were granted in as a territory, and they succeeded. In fact, Teddy Roosevelt of Thomas Hart Benton said, he began his fight for the disposing of the public lands. It was a move of enormous importance to the whole West. His long and sturdy contest entitled him to the greatest credit. He never gave up the struggle, although he had to encounter much opposition, especially from short-sighted, selfish Northeasterners. As a whole, his theory of a liberal system of land distribution was undoubtedly the correct one, and he deserves credit for having pursued it as he did. You see, this has already been done before. The promises at statehood are the same. It really is the only solution big enough to get to better access, better health, better productivity of our lives. Look forward to further discussion. Thank you very much.
Thank you, Representative Ivory. Now providing the perspective in opposition to the transfer of public lands is Doug Young. Doug joined the Keystone Center as a senior associate in September of 2014. He has been involved in major public policy decisions related to the environment, public lands, natural resources, energy, and transportation over the past 25 years. He has worked to resolve controversies in these areas and strive to find common ground for the mutual benefit of the varied interests and values they bring. His work with many elected officials at the federal, state, and local levels has principally involved mediating disputes, addressing concerns, and finding creative ways to accommodate all views within existing laws, regulations, and policies. He has also helped draft these laws and policies, which require an understanding of the needs of the communities in private interest, while protecting the values of a healthy, productive environment and the full, robust, and active participation of the citizens. So, Derek, I will allow 20 to 30 minutes.
Is this the mic? Can you guys hear me? No? Better? They have to hold it. I'll hold it. So as Dave just went through that bio, I guess I'm struggling here to decide whether I'm going to be an actual con. It's not in my nature to be a con, nor a Fed, although I have worked for the United States House of Representatives as well as the United States Senate. You'll have to indulge me a little bit in terms of how robust I am con, because my nature is to resolve disputes as Dave described in terms of the Keystone Center. Our whole function, we originated here in Colorado, our whole mission is to try to resolve disputes and reach consensus building from disputing parties and entities. So this would be, for example, an example of the kind of thing that we might facilitate this very kind of topic. So I just want to give that disclosure right up front how strong I'll be on this. But let me start by saying a couple of things, and we'll just sort of walk through this. One way I could have done this, and I was preparing to do this, is just sort of build the theory or the point of view legally and policy-wise as to why we ought to maintain federal lands in federal ownership. And I'm prepared to do that. But I also, in listening to Ken's presentation, thought maybe there might be a different way to go with this, in a way to be respectful to the idea of being a con. So I wanted to just disclose that right up front, that I could go through and respond to the points that Ken has made and do it in a way that would be what I would think the opposable argument, versus sort of building in a proactive way, what the argument and how the argument would flow in terms of maintaining these lands in federal ownership. So I might mix the two to start with. But generally speaking, and I apologize if I insult anybody's intelligence, but this whole concept springs from the notion of what's called the equal footing doctrine, which is a provision in the United States Constitution that essentially says states as they enter the Union have to be on an equal footing with the existing states at the time. The whole concept around equal footing was really designed, now if you guys can imagine that I was going to first ask this question: how many believe in your heart of hearts that the western states are unequal to the eastern states or any other part of this country? Seriously, that we do not have the same health care provisions, the same educational opportunities, the same economic opportunities, that we don't have representation in Congress. If you're looking at equality, what is equal? You can talk about equal in its complete pure sense, meaning that we've got to be precisely the same as New York, which means that Colorado should have the exact number of members of Congress, if that's equal. So if you think about equal, not even in my humble opinion, I'm not a constitutional scholar, but in my humble opinion, even that provision in the United States Constitution did not envision pure equality. What it envisioned was that those new states that came into the Union would be equal in the sense of the kinds of political and processes they would have. There would be a democratic state. They would enjoy the benefits of the United States Constitution, the Bill of Rights. It was primarily a social and governmental kind of concept. It was not designed to be purely and absolutely equal in that sense. I don't think the founders had interpreted it that way. Since that provision, there has been lots of court cases and judicial doctrine developed around what the equal footing doctrine means. And primarily the courts have determined that it's a one-way concept. What it means is that Congress cannot condition a state to have something or do something in order to become part of the union. There cannot be a contract or a covenant or a provision that requires the state to do X, Y, and Z in order to secure the full rights and benefits as being a member of the United States of America. So most of the court cases involves conditions that Congress was seeking to place or requirements they were asking territories to perform in order to become members of the union. Well, most of the litigation, or some litigation, determines that, because this has been tested in some cases about what it means about property. Primarily, the rule has been that when it comes to property, because remember we're talking, not the other stuff that would make you equal, meaning that you can have senators, you can have 3 branches of government, those kinds of equality things, is that you can't, the states do not then thereby condition the federal government in terms of what it can require by way of having equal footing in its enabling act. So primarily it's been one way. Congress cannot condition a covenant that requires that territory to do X. On the other hand, the courts have said, look, what the state gets when it becomes into the union is whatever it gets that is not encumbered by Congress otherwise. And when it comes to property, this nation, at least with regard to most of what the West, in terms of what it can be shown in your map, it was owned by us as a union, owned by us federally. It was not owned by the individual or the states, because they weren't in existence at the time. They were territories. So that ownership. That ownership and management was in the federal government. And the federal government could have chosen during the enabling acts to say, we will allow you to come in and we will give you all of this property. Again, that's not a one-way condition. It says we'll give this to you. So what I guess my point is that the way that the equal footing doctrine is in the Constitution was primarily a proscription, a prohibition on what Congress could say, but it did not prohibit what Congress could choose to do by granting additional things to these states, meaning that they could choose to surrender that property to the states. It was Congress's choice. So constitutionally, this restriction on Congress was only on the condition, not on whatever thing it would want to grant. So I agree with Ken that all of those issues that he articulated as being concerns of this nation are real. Where I get tripped up is whether this concept of transferring federal land ownerships would solve those problems in the way that he would like to see them solved. So let me start with one, which I started at the very beginning, which is the presumption that the states are not equal. I personally don't think that the states in this country are unequal in that sense. They're all unique and they have their own situations. So I don't, the presumption that we are at a disadvantage because we have federal land ownership, that's a premise I don't, as a con argument, don't agree with or don't buy into. The second point that Ken made is that we have a federal budget balance problem. And again, I agree with that as being a problem. The question becomes whether, before I get into that, I guess the point I was going to say is, Ken is right that, to me, I see this as an accident of history, for lack of a better phraseology. If the Western states had more of a population and more of a drive and a political will to demand that the federal government relinquish that federal land as part of the creation of those individual states, we might not be in the situation we're in. What I'm saying is that I don't think it's a legal concept. I think for me, it's a little more problematic if, in making this point about the disposal of federal land, that you're making an argument that it's a constitutional argument or a legal argument. My view is that that's a weak one, and I think you're going to have difficulty meeting that based upon the jurisprudence and what the court says. But what you can do, or what historically, what would have been preferable is when we became a state of Colorado, had we had a concerted effort, like we did in other states that Ken mentioned, to say, we demand that these lands be transferred as part of statehood. That's when it would have happened. That's when we should have done this. To do it today, to me, seems a problematic for the reasons that I was just about to go through, which is to sort of respond to each of Ken's points. One is, I think it's going to be hard to rebut the notion in this country nationally that the western states are unequal. I think a number of states will probably say we envy the federal public lands in the West because of what they provide by way of beauty, tourism, clean air, clean water, wildlife, abundance, those kinds of things. So again, please indulge me that this is the con argument, okay, that I am making, that you all, I think, would need to think about if you're going to advance this case. I think you have to acknowledge that there will be some who will say all states are equal in the largest sense of that term. And to suggest that the western states are unequal because they have federal land is going to be a weak one, because some people believe that federal lands are a plus, not a negative. The second point about the federal budget deficit, I would submit, after working for senator and congresspeople, that if you were to say that we could deal with the federal budget deficit problem by transferring federal lands to the state, you will immediately get resistance from an entity called the Congressional Budget Office. The Congressional Budget Office reviews legislation that's proposed, and in my view, if you were to do this, it would require an act of Congress to transfer these lands. That the Congressional Budget Office will likely say that the revenue that would be lost to the federal taxpayer will greatly outnumber the amount of revenue that might be generated by state ownership and through, state income taxes and the like, just the multiplier effect for the kind of economic activity that would be generated from state ownership. So you will face immediately, I'm just again going through the practical realities of issues with entities of Congress that will likely say, transfer of federal lands will not help the federal budget deficit. In fact, it may actually hurt it and make things even worse. Ken's points, again, are real. I mean, these are real issues and problems. But he did show that the federal budget is going down. So we've got a budget deficit problem, meaning the revenue is not matching up with the spending. And I would venture to say that it's not the federal, or it's not the western states' federal land ownership that causes this budget problem. The budget problem is caused by a whole other factors, which you guys could probably recite for us right now. Lowering taxes. The fact that people are driving further with less gallons of gas. All kinds of efficiencies in the system. So there's a whole host of reasons why there is a federal budget deficit and an income gap. And I just don't believe that the reason for that is the fact that the western states own the federal government owns the western lands in the western states. On the rare earth minerals question, again, I think Ken makes a very good point. We need to be more secure when it comes to minerals and mineral development. The question is, does federal ownership of federal lands mean that we will not be able to develop our rare earth minerals? Maybe. But if it was transferred, if all those lands were transferred to the state, does that therefore mean that we will develop those rare earth minerals? My thinking is that the same issues and the same values that apply to concerns of resource impact and environmental impact from development of rare earth minerals will exist at the federal level as well as the state level. If these were transferred to the state of Colorado and the state chose to extract in a very extensive way a rare earth mineral on those now state lands that used to be federal lands, the state of Colorado would encounter a number of people who would object. There will be concerns about the environment, the impact of that mining activity, water quality, you name it. I'm just simply, again, saying on the con side that the solution of transfer doesn't necessarily solve or result in extensive development of rare earth minerals. It's not, to me, a do this, then you get that. Fires, wildfires in the West. Again, I think this is a very serious problem, and in all of the jobs I've worked at, we have struggled with how to improve forest health and increase the tools and abilities to reduce fire threats on our national forest lands and public lands generally. But again, the issue about that, to me, isn't solved by transfer to states or the federal public lands. The issue of fires, because of the practices that we have all bought into throughout this country of fire suppression, and the fact that a number of areas within the West do not have marketable timber. The value of that timber does not lend itself to an economically recoverable way to remove it. And that issue is real to the federal government as it manages forest lands. To the same degree, it will be real to states if they were to receive these properties in a transfer. So again, I don't necessarily think transferring these lands to the states will result in less fire threat. The more we have growth and development of homes and communities within these forested landscapes, the more we're going to have fire threats and fire risks. And the health of the forest is a function of management generally. And the question will be whether the states have the financial wherewithal to manage that forest resource in a way to reduce that fire threat. And it's the same kind of cost accounting that would result in states as it does the federal government. Access issues. I'm not disputing Ken's points that these are real issues. They are real, and we got to struggle with them. But again, I don't make the leap, I'm sorry if I'm sounding like a broken record, of transferring federal lands to the states is going to necessarily, in all cases, and I want to qualify that, result in greater access to natural resources. I was going to say access to public lands, but if it was transferred to the states, we don't necessarily know if it will continue to be public or not. Maybe not. But the other complication to that is that access is not just a function of whether the federal government has decided to close a trail or prevent off-road or access to that particular region. It can also be because of private lands. And as hunters and sports people know, sometimes they cannot reach public lands because there is a private land holding that prevents access to that public land. So I'm just saying that I don't think that transfer necessarily magically solves that everywhere and at all times. Ken also mentioned this idea that we've locked this. He showed the map about how much we've locked this stuff up. Since it's in federal ownership, it's now locked up. Well, I would venture to say that some people would argue that that's not the case. The 1872 mining law, for example, allows anybody to go anywhere on federal public lands to locate a mineral. Anywhere place that has not been withdrawn.
The law is written since it has amended.
Sorry. Unless there's an area that's been withdrawn by Congress saying that you cannot enter and stake a locatable claim under the 1872 mining law, every place is open. The same is true of the Mineral Leasing Act, which again deals with fossil fuels development on federal public lands. Anybody who seeks to develop that resource, a company, producer, can go to the BLM and say, we want you to offer this out to lease. And it's very incumbent upon that agency to open it up for a lease. I don't know what kind of scenario or situation or dynamic would exist if we were to transfer these lands from that ownership into state ownership. They may be more permissive, they may not be. I'm just saying that the presumption that these are locked up kind of is in the eye of the beholder based upon what the laws of this country say, at least in those two examples. Ken also used the terminology that we gave up this land at statehood. And I don't know who the we is unless it's people of Colorado, or at least people of Colorado at the time. He may be right in the sense that
the people who were here in Colorado at the time surrendered that because they didn't fight Congress as strong as the other states did to say, in our Enabling Act, we're going to demand and we're going to ask our colleagues in Congress to pass an Enabling Act that transfers this. So it's this land, especially in the West, because the way it was acquired through international treaty and the like, was not owned by the people of the state of Colorado at statehood. It was owned by the nation. And so we didn't essentially give it up in that sense. We may have given it up in the sense that Ken mentioned that we didn't fight like those other states in the central part of the country to say we demand that that be part of the Enabling Act and we secure those. I just wanted to again, I'm being as calm as I possibly can. Try to read my handwriting, excuse me.
About 5 minutes.
Okay. I can keep going, but why don't I just stop there with 5 minutes because we can open up for more questions. We'll open it up for questions, so because I know there's folks anxious to do that. Thank you all very much.